This is a meeting of the Athens Board of Zoning Appeals. The time is 7 o'clock and the date is June 15, 2011. At this time, I will call the meeting to order. The board consists of 5 members and 2 alternates, with alternates taking full part in the discussions and becoming a voting member in the absence of a member or when a member abstains for conflict of interest. Present tonight are Michelle Drabo, John Gulsey, Greg Lavelle, Joan Kronowski, Lisa Carson, and Kate Housley. I am Betty Hollow, the acting chair. Also present are Zoning Administrator John Pesky and Secretary Paul Eschenbacher. Also, Pat Lang, our Law Director, is with us tonight. The board operates according to the following procedure. The chair will name and describe the case. The zoning administrator or secretary will state the basis of the objection and any applicable facts or conditions pertaining to the case. The appellant or their representative will give reasons why the appeal should be viewed favorably. Anyone wishing to speak in favor of the request will be heard. Anyone wishing to speak in general comment will be heard. Anyone wishing to speak in opposition will be heard. If necessary, the appellant or their representative will offer concluding summary or rebuttal remarks. Testimony from the floor shall be closed. The board will deliberate and render a decision. According to Athens City Code, Section 230703B, the board has power to grant variances from the strict application of the code, provided the variance will not be contrary to the public interest, the spirit of the code is observed, public safety and welfare are secured, and substantial justice is done. According to Athens City Code, Section 230710C, variances from the code shall not be granted unless the board finds, based on direct, specific findings of fact, that each of the following conditions have been supported. First is practical difficulty and undue hardship. Because of exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property, a literal enforcement of these regulations will result in practical difficulty or undue hardship that is unnecessary to the achievement of public purposes. Exceptional circumstances. There are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone. Preservation of equal property rights. Literal interpretation of these regulations would deprive the appellant of rights commonly enjoyed by others in the same zone in the same vicinity, while granting of the requested variance will not confer on the applicant any special privilege that is denied to other properties in the same zone or the same vicinity. Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property. Absence of detriment. The authorizing of such variance will not be a substantial detriment to adjacent property and will not materially impair the purpose of the zoning code or public interest. Not of a general nature. The condition or situation of the specific piece of property or the intended use of said property for which the variance is sought, one or the other or in combination, is not of so general or recurrent in nature as to make reasonably practicable the formulation of a general regulation for such condition or situation. The board also has the power to review decisions of the zoning administrator where an error is alleged. He requests for conditionally permitted uses. He requests for substitution of non-conforming uses, determine the number of required off-street parking spaces if the specific use is not contained in Section 2311 Table B. He requests for temporary use of structures or premises, consider requests for extension of temporary permits after receiving a recommendation from the Athens City Planning Commission. He requests for business use variances after receiving a recommendation from the City Planning Commission, and he requests for variance from the strict application of the City Title 25 flood damage prevention. Any person, resident, or officer, department, or appointed body of the City of Athens aggrieved by the decision of the board may petition the Athens County Court of Common Pleas concerning the illegality of the decision. Such petition must be filed within 30 days after the mailing of the decision of the board to the applicant. There are 4 cases on the agenda tonight. Section 1107B, 2131 East State Street. The appellant is Troy Miller of the Holzer Clinic. Excuse me. The second case is 1109B at 34 Grosvenor Street. The appellant is Laura A. Lawson. She is requesting a variance from ACC 23-1001, Table A, Schedule of Bulk Controls. Case 1110B is at 15 Mulligan Road, Trent Clark Circle Construction is the appellant. They're requesting a variance from bulk controls to allow construction of an addition to a house that needs setback amendments. Case 11B is at 9, is at West Stimson Avenue, 3 Wide Entertainment is the appellant. They're requesting an administrative review by the board regarding the decision of the zoning administrator to deny establishment of an adult theater. Let's see. The board is required to take testimony under oath. So, would anyone wishing to speak concerning any item on the agenda, please stand. Do you swear or affirm? Okay, I'm going to say this again. Anyone who wishes to say anything at all tonight needs to be sworn in, okay? If you want to say a single word to us. Okay. Is that everybody? Okay. Do you swear or affirm that any testimony you will present to the board will be the truth, the whole truth, and nothing but the truth? Okay, the first case tonight, 1107B at 2131 East State Street. The appellant is Troy Miller for the Holzer Clinic. And again, they're requesting a variance from ACC 2303-13K to allow placement of an off-site directional sign to a business where such business is allowed only for a church, school, community center, library, hospital, museum, public art gallery, cultural arts center, or similar public or semi-public institutional building. This is a case that was continued from the last meeting when we decided that perhaps we needed a bit more information than we had on hand at the time. So I'm expecting that Mr. Miller will take, hold on a minute, I'm out of order. Let's let Mr. Eschenbacher tell us a bit about the case and get us up to speed.
Well, just to review, that we did do the case last month, and the board heard testimony from the zoning administrator, myself, and the appellant, and then closed the floor for discussion. And then on a motion by Ms. Kronansky, seconded by Mr. Golsey, the board considered to grant a variance from ACC 2303-13K to allow placement of an off-site directional sign, illuminated and 1 foot by 3 feet in size, to a business where such sign is allowed only for a church, school, community center, etc. The board went through findings for hardship and difficulty. They listed the road was changed by the Ohio Department of Transportation, and locating the motel was made slightly more difficult. The street could have been named. There would be a hardship created by denying variance. For exceptional circumstances, the board put that the road was changed and that the motel had a deal with the clinic to allow the sign. For preservation of equal property rights, 16 other businesses will ask for the same thing. The clinic will already have a large sign. For minimum variance, the sign will be lit. It is minimum in size. For absence of detriment, it would be there to help negotiate traffic. 2 signs were allowed for the clinic previously. The sign is tacky. It is fair to have the sign. And for not of a general nature, the board said that yes, it is not of a general nature. At that point, the chairperson called for a vote. And Ms. Draybold said that she wanted clarification of information from Andy Stone, who is the head of engineering and public works for the city. The board decided to table the meeting until they could get that information from Mr. Stone. In the meantime, Mr. Stone, who was unable to be here tonight, did write a letter that I included in your information packets. So, depending on how you want to handle it, if you want to give Mr. Miller the opportunity to give any additional information, you can. I would recommend to make sure that the board still agrees on the wording of the motion in case any information that they received from Mr. Stone has changed anything that they want to do, and to see if they wish to add anything to the findings.
Okay. Okay. This is a rather lengthy letter, and I don't know if you feel we should read it into the...
Well, I think you could have probably asked if all voting board members have read the letter.
All right, have you read this?
Yes.
Yes. And questions, comments, things you feel satisfied or dissatisfied with, given this information?
Well, it satisfied me to give me a timeline as to what some of the conversation had been regarding the lead-up to the sign and what had been going on, which was not clear to me last month. So that did help me understand the timeline and what was going on, and I would like to hear from Mr. Patel tonight, if
Okay.
he's available.
Okay. Mr. Patel? Is Mr. Patel here? Not yet. We'll get you up here in just a minute, okay? Anybody else with questions, comments in relation to Mr. Stone's letter to us?
I was satisfied.
Okay. And what is your question then, Joan?
I had some concerns about the positioning of additional signs,
Okay.
but I think since we brought in city officials that were engaged in this and could see a much more varied and open discussion of this, I was satisfied with
Okay.
his comments.
Okay. So I am assuming then that we have the additional information that was requested. So at this point, we can hear what you would like to say, Mr. Patel, if anything, or Mr. Miller, or both of you. Which first?
Like to say the board was for Pakistan.
Okay.
Sign, we have sign problem in night time.
Okay.
When people take exit and this thinking Super 8 sign is there, so have an entrance there, people go to stay there, they never find the entrance, they go to far. And after they call and sometimes they never come back and they looking for. I affect over 20 to 25% business is less business around. In night time, nobody have to see the entrance is there. Everybody make one big sign is there, and before our entrance is there, so everybody go that state. And after there doesn't have a U-turn and anything, so you go to Hampton, Holiday, and anywhere there.
Okay. Anybody got this particular questions for Mr. Patel?
Mr. Patel, I wonder, are you allowed in some capacity to be on the hotel, motel signage, the state sign that's on the exit? That points?
Sorry, sir?
Are you able to put your hotel listed with the other hotels that are on the state sign on the highway, pointing to their locations? Are you able to advertise on that sign?
From my understanding is that they discontinued that service.
Discontinue that service.
That's my understanding.
Are you aware of the sign that states, are you aware of this?
Yes, we all.
Is the general manager here, and his brother is actually the one who does the
One
paperwork.
that-
And I did talk to him about,
Hold on just a minute. We didn't ask Mr. Patel to tell us his name and address.
okay.
Mr.
You
Patel,
guys
will
know
you do
your
that?
name and your address?
My name is Mahendra Patel,
Yes.
and our address is 2091 East Street, Athens.
Okay, just for the record. And now, Mr. Miller? Okay, would you like to help out here?
Sure. So I talked to
Again, tell us your name.
Troy Miller, 2131 East State Street. I did talk to his brother about the sign. It's an application process. I'm not sure that I was aware. Well, I know I was not aware if he was on the sign before or not. The exit sign is where, like the blue signs, is that what we're talking about?
Yes, the large blue sign that indicate the other three.
Okay, yeah, I'm not sure. I asked him about if he was doing that. He said it's an application process, and that's kind of where it stopped. I mean, their main concern is like really when you come down off the exit. It used to be when you came off the exit, when you came off the exit, like basically the turn-in was right at their hotel. And so now when you come off the exit, there's nothing there that says go straight across and then go down the lane in front of Super 8. So people are turning onto East State Street, going back under the bridge, and there was nowhere to turn to get to the hotel. So, when it was all discussed, which was prior to me being involved with any of this, but when it was all determined a couple years ago, they talked about moving the entrance, and one of the criteria, out of all the businesses that were there, they met with every business that was there, and John, you may be able to speak to this more than I can, but they spoke to every business that was there, and Super 8 felt that they were going to be the most affected because the driveway was right into Super 8. And so, they were like, hey, well, we would like a directional sign, and, again, I wasn't involved, but they got an agreement with Holzer, and now it's for me to bring to the board.
And motel business is nighttime business, it's not daytime. So other people doesn't hurt that one. Nighttime people when come in midnight and anything, they go straight. And second thing, that other sign they put in, that nobody see in Super 8 small logo and the immediate turn right and nobody see. Super 8 separate sign, everybody see and they have to come inside of the
Any other questions from these gentlemen? Okay. We can call you back if need be. In the meantime, is there anyone who would like to speak in agreement? Is anyone who wishes to speak in general comment? Is anyone in opposition? Okay. I think we probably know where we are. You feel that you need to say, tell us anything else? Yeah.
No.
Okay. And in fact, we were really almost at the point of voting the last time we were here. We had been through the findings already, as Mr. Eschenbacher has reviewed for us. So now, we'll close the floor and have any discussion that you want to have. We've been through the findings. Any new comments that you would like to make, one way or the other?
No?
Okay. Yeah, okay. Let's start with Ms. Grable.
Yes.
Yes.
No?
Yes.
Okay? And I also will vote yes. So you will have the variance. Okay? And the sign. Okay. Okay, our second case tonight is 1109B. It's 134 Grosvenor Street. This is in an R1 district. The appellant is Laura A. Lawson. She's requesting a variance from AAC 231001, Table A, Schedule of Bulk Control, to allow construction of an attached deck to a house with a total lot coverage of 40%, where 30% is the maximum allowed, and from ACC 230801 to allow elimination of one on-site parking space, where the requirement is to retain on-site parking. So, Ms. Lawson? Mr. Paskey?
Paskey.
I'm sorry, can you hold on a minute? Can't seem to get this straight. Mr. Eschenbacher, what can you tell us?
Well, it's a pretty straightforward request. I would want to point out to the board, though, that there appears to be a discrepancy in what Ms. Larson put in her letter about that it would not affect the parking space, the proposed deck. But if you look at the diagram, the drawing that she provided, the proposed deck that is drawn on there is not drawn to scale with the rest of the drawing, and in fact, if you do extend it to the actual size, it would be over at least part of the parking space. That's assuming that all the measurements and the placement of the parking space is correct on the drawing. So in my opinion, the proposed deck would in fact affect the parking space to the point that it would not be large enough to be legal for a parking space. So that's just what I want to point out. That's why the variance is worded the way it is.
Okay, so she is actually requesting the elimination of that parking space.
Well, she just wanted, she originally just thought it would be for lot coverage. In our refusal of it, we decided both.
Now, Ms. Wilson.
My request is to build a deck that would be coming off of my home, 10 feet by 12 feet. It's a non-conforming lot, so the residence right now takes up 32.7%. This deck would be, there are no stairs that would come down to the property. It would be private, simply from my home. And according to my measurements, it would come out, and the posts would come right to the edge of the parking space. I guess there's a discrepancy. The house, we live, on a ridge, and there's essentially all of this outdoor space that is, I can't use in any kind of productive way for my family. And this is sort of a way that I can kind of make an outdoor space for my family. It doesn't pose an imposition either sort of visually or physically to the neighboring properties. And again, according to my calculations, it doesn't even impose upon the parking space, which meets the sort of size regulations as stipulated by the city.
Questions?
I have a question. Do you have a window or a door at the opposite end of where you have your deck and door drawn, that it would be possible to access a deck through that side of the house that would not go towards the driveway in your parking space?
No, I'm going to build it off of my kitchen, so the door will open up onto the deck, but I'm not going to make stairs that will go down to the actual back part of the lot. So the only means of access is from the inside of my house, from the kitchen.
I think what Mr. Lavelle is asking you is it possible not to use the access from the kitchen, but to put the deck on the other side of your house and access it from some other room, so it won't interfere with parking space?
It would be very sort of awkward architecturally. It would mean that I would have to sort of walk all the way around my house, down the sort of alley, into the back, to kind of access the deck. From the inside, that side of the house is where my bathroom and a closet is. So having an access from my bathroom is not kind of ideal. Okay.
Thank you.
Other questions?
Yeah, I have a question perhaps for Paul Eschenmacher. The reason that the deck, how short does the deck extension interfere with the parking space? I'm assuming it's not height.
No, it's just, we assume that because of the construction of the proposed deck, that there would be posts at the end that stick out. Again, looking at that drawing, if it is indeed 10 by 12 feet, it looks like it would extend probably about halfway across that gravel drive space there. So I would say it would take up probably 4 or 5 feet of that parking space on that side. If again, this is an accurate drawing as to where the gravel drive is.
Well, I physically looked at it, and it looked high enough so that it would almost create a carport.
Well, I mean,
If you extend it a little farther?
well, see, that's it. That's why from my measurements, it looks like those posts would go right down in the middle of the parking space. She could propose to make a bigger deck so it would stick out completely across there, but of course that would mean greater lot coverage and a bigger deck, and then possibility of consideration of a minimum variance would come into play there. So I'm just measuring, going by what she asked for, which is a 10 by 12 deck, and where that would be placed in relation to the parking space. So, in my opinion, it would stick into that gravel drive, that parking space, 4 to 5 feet. And those posts would probably wind up right in the middle. But she's indicating that it wouldn't, so all I can say is that perhaps the gravel drive is further down the hill than what this drawing indicates.
I thought it was directly abutting the house, which I thought it was closer to the house and farther away, which according to this drawing then would be incorrect. But, I mean, that's what I saw when I looked at it.
Well, I'd be terribly embarrassed if I measured it properly, but I'll just add that the parking spot is accessible only through the alleyway, and I pay for parking somewhere else. It's actually not very usable as a parking space, and it exists, and it sort of meets code as I understand it, like when I purchased the house, but my interests are primarily in sort of making a sort of viable outdoor space. When I measured it, it came right at the sort of edge.
Table
Yeah, I think maybe if we can
Table
better
one.
drawings,
Let's go
maybe.
measure.
How would you feel about that, Mr. Eschenbach and Ms. Lawson, remeasuring together, perhaps?
I have no problem with it.
Okay, I think it's very
Make sure
difficult
it's
for us to
accurate.
make a decision tonight if there's some contention about whether this is obstructing or not obstructing the parking place.
Okay,
Is that agreeable to you?
sure.
Okay.
I mean, this means delaying it a month, I presume.
Yes.
Okay. All right. Are we supposed to take a vote or something?
Just table it.
Okay. I
think it's
All right,
tabled.
it's tabled, okay. So they'll put you on the agenda, I'm sure, for the next meeting, okay?
Okay.
And if you and Mr. Eschenbacher could get together and make some accurate decision about those dimensions, that would be helpful to us. Okay. And to you, I think. Okay.
Thank you.
All right. The third case that we have tonight is at 15 Mulligan Road. It's case 1110V. This is in an R1 district. Trent Clark and Circle Construction are the appellants. The appellant is requesting a variance from ACC 2310-01, Table A, Schedule of Bulk Controls, to allow construction of an addition to a house with a rear setback of 20 feet, where 30 feet is the minimum requirement. So, Mr. Eschenbacher.
Again, the request to replace the pergola there with a screened-in porch. The porch would not take up any more space than the outdoor area that's already there, the pergola and the roof. It would not stick out any further, either rear or to the side. And one thing I did want to point out to the board that I forgot to include, which is a plat of the property in the area. Directly behind these two lots that the owners own is a city alley. So the 20 feet goes to the back edge of the property, and then behind that is a city alley that's measured 12.6 feet. So there is actually 32.6 feet from the back of the house to the next neighboring property behind 15 Mulligan.
Well, that is sort of in the map, if you look at the plat.
When I pulled out the original application for the house, I think they accidentally measured off the wrong side of the alley when they staked the house out, and it was built in the, 78 or 77? Because the whole house is actually set that way.
Okay. In that case, let us ask Mr. Clark if he would like to speak to us.
I guess maybe just to make sure that everyone has seen that picture of what the back of that property looks like, that there's There's no housing behind that. And that alleyway has never been developed, you know, that little piece here that belongs to the city, we'll say. Oh, I'm Trent
Sorry.
Clark from
Thank you.
Surface Construction.
Thank you.
And that's
Have you
40
address? Do you have an address?
Yeah, it's 4960
Okay,
South State Route 555, Chester Hill.
thank you.
But in any case there, that piece of that alley there that we was talking about, you know, that's not paved, that's basically a wooded lot. So I guess maybe, just so everyone was clear, anything if that's set to do that, nothing from that can be seen from the street, from the neighbor, from the other neighbor. Basically, that's all just empty land back here. So I guess that's pretty straightforward what we was trying to do with that.
You might tell us the size of this addition?
The height of the proposed roof structure. Okay, that pergola that's back
It's
here.
really the pergola. Tell us the dimensions.
Oh, the dimensions
Yeah,
on that?
right.
It is, I believe it is 19 foot wide and 12 foot in depth from the house to the rear of the property. Do you guys have a partial picture of that?
We do, yeah.
Okay. Yeah, that pergola lands basically right from the back of the house, and then there's a deck back behind that, which is nothing to do with anything we're fooling with right now.
Okay, so basically you're just making a room out of what used to be a more open
Yeah, we're not
outside space.
building a foundation or nothing, we're just basically taking off that pergola. Put some better framing up there and putting a clear panel on that and screening in the area.
Okay, so would you call it a screen porch rather
Yeah.
than a room?
Yeah.
And I don't believe it's any further than the existing rear of the house, correct? It's an L-shaped house.
Right, yeah, it doesn't go any, in that little dead L shape, it doesn't go any farther than off to the other side of that. Must be a bedroom or something there. It doesn't project farther than the back of the house currently is.
All right. Questions for Mr. Trent? Clark, Mr. Clark, do you have questions with him? Anyone? Okay. We will let you resume your seat, and we can call you back if need be. In the meantime, is there anyone who wishes to speak in agreement with this possible variance? Anyone who wants to speak in general comment? Anyone in opposition to this proposal? Okay. In that case, let's close the floor and we can have a discussion and/or go through the findings and see what we think. Any discussion ahead of time, or you just want to go through the findings?
The motion, maybe.
I have a motion, thanks.
I move that we grant variance to the case 11-10V. Trent Clark, Circle Construction Appellant. He's asking a variance from code 23.10.01, Table A, Schedule of Bulk Controls, to allow construction of an addition to a house with a rear setback of 20 feet, where 30 feet is the minimum requirement.
Second.
Okay. So, the first thing to consider is the practical difficulty or undue hardship because of exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property. A literal enforcement will result in practical difficulty or undue hardship that is unnecessary to the achievement of public purposes. What do you say?
Well, the appellant mentioned something in her letter, or their letter, about needing to replace the pergola. And also, they were looking to screen in the porch because of bugs and allergies to bees and things like that.
Okay. Exceptional circumstances. They are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone.
I don't know about the other houses in the area, but this house sits back 95 feet, so the front setback is very large. There's still a lot of lot space uncovered, so I think that more compensates for the usage in the rear.
Okay. And they have pointed out that there's also an alley behind to extend that space. Preservation of equal property rights. Literal interpretation of these regulations would deprive the appellant of rights commonly enjoyed by others in the same zone and the same vicinity, while a granting of the requested variance will not confer on the applicant any special privilege that's denied to other properties in the same zone and the same vicinity.
Others have porches the same way,
Yes.
screen porches.
In a wooded area like
Okay.
this.
Yes, and again, it's not going to extend any farther out than the back of the house already is extending on the other side. Okay. The variance granted is the minimum variance required to make possible the reasonable use of the property.
It is minimum.
Yes.
Yes.
Absence of detriment, the authorizing of such variance will not be a substantial detriment to adjacent property and will not materially impair the purpose of the zoning code or the public interest.
No one will ever see it.
Okay. Matter of general nature. The condition or situation of the specific piece of property or the intended use of said property for which the variance is sought, one or the other in combination, is not of so general or recurrent in nature as to make reasonably practicable the formulation of a general regulation for such condition or situation.
No. Yes, it's not of a general nature.
Yes, it's not a general nature. Okay, thank you very much. Okay, so you ready to vote? We'll start with Ms. Kronowski.
Yes.
Yes.
Mr. Lavelle?
Yes.
Yes. And I will also vote yes. So, you will have the variance. Okay.